The biggest mistakes that people make when they initially apply for long-term disability benefits, there's a lot of them, and I've been practicing for 21 years, and I can pretty much predict the mistakes that people are going to make. And one of the primary mistakes that people make is that they fail to adequately document their physical or mental decline with their physicians. If a person has a degenerative spine condition, or perhaps a degenerative neurological condition, the insurance company is going to look at your claim and say, well, what's changed? Well, if you just go in and speak to your physician on a regular basis and don't bother to let him know that you're feeling a lot worse, the insurance company isn't going to see any change in your condition. So ensure that you communicate with your physician. And more importantly, ensure that your physician, and more often than not, they're very busy when they're typing in their medical records, documents the fact that you're declining, whether you feel worse or your imaging studies show that you have a decline in your physical condition. Ensure that's in the records. Also, a big mistake people make is that they don't ensure that their physician supports their disability. It's really important that your physician is willing, let's say, to fill out the paperwork in the first place, because often they're busy. You should discuss this with your physician. Also, the mistake that people make is they don't understand the definition of disability in their policies. For example, a physician may be, let's say he's an orthopedic surgeon. He may have another occupation where he is either designing surgical instruments, or perhaps he's an expert witness and deriving income from that job. Well, under most disability policies, with very rare exceptions, you're going to have two different occupations. So if you're unable to perform your duties as an orthopedic surgeon, but you can still continue as an expert witness or an engineer for various surgical instruments, if you can still do that, you're not going to be totally disabled. Another mistake that people make is they think that disease equals disability. It doesn't. Someone with an unfortunate case of cancer, maybe they're riddled throughout with cancer, may very well be able to perform their duties. What defines disability, really, is your restrictions and limitations. There's two elements to every disability claim. One is, what were you doing? What were your physical duties prior to the onset of your disability? And the second element is, can you do that any longer? So it's important that you understand that you have to document your restrictions and limitations. A diagnosis is not simply enough. And I think really the last big mistake that people make is by allowing their treating physician to speak with the insurance company, either the claim representative or more typically with an insurance company doctor. And here's why. The insurance company doctor will call your treating physician. Often he's walking down a hall or past his receptionist's desk, and they say, phone call for you. He'll pick it up. He's not familiar with your case. He'll give a couple of brief answers, not understanding their import. And essentially the questions are designed to eliminate your claim. Then the insurance companies follow up with a letter and say, hey, this is what you said. And the physician, again, being busy, will just sign it and go on to, treating patients during the course of his busy day. So those are some of the major mistakes that I see that people make initially applying for long-term disability. How important is your treating physician to your long-term disability claim? Well, very. In fact, without the support of your treating physician, your claim is really going to go nowhere. It's upon that physician that your claim relies. In fact, one of 3 claim forms sent out at the initiation of a claim is sent to your treating physician. And absent his support, the insurance company has absolutely no reason to find that you're disabled. So prior to filing a claim, I think it's really important you discuss with your treating physician that you are going to be filing a claim and ensure that he'll support it or she'll support it. Absent that, you're really kind of wasting your time. Can you live your life when you file a long-term disability claim, or are you going to be under constant surveillance? And the sad answer is, for anyone with a long-term disability claim, that you probably will be surveilled at one point during your claim, whether it's at the initiation of the claim or more often at the termination of a claim. You can count on an insurance company sending out a private investigator or maybe two private investigators armed with a video camera and a zeal for finding you doing things that are inconsistent with your stated restrictions and limitations. And, really the only place that you're free from video surveillance, and this changes, of course, depending on the state that you live in, is where you have a reasonable expectation of privacy. And where do you have a reasonable expectation of privacy? Well, it might surprise you to learn there are very few spots or spaces where you have a reasonable expectation of privacy. In fact, I'd say anytime you're outside of the confines of your own home, you don't have a reasonable expectation of privacy. Indeed, I've seen long-term disability claims denied because a person was taking out their garbage. Now, it's a rolling garbage can, but they claimed to have a back problem. I've seen a claim denied when a guy lifted a six-pack of beer and put it in the front seat of his truck. The reason he put it in the front seat of his truck was because he would have to bend over to put it in his trunk, and he didn't want to do that. Also, you can count on surveillance more frequently on the weekends. This is when people tend to go to Costco and lift those heavy cartons, trays of beverages, and take them off the bottom of the cart and put them in their trunk. But you can also expect them in your church or in your gym. So you always have to count on being surveilled. You can live your life, just know that the insurance companies are going to try to find that you are engaging in physical activities inconsistent with your stated restrictions and limitations. The insurance companies don't look at your social media, do they? Well, let me tell you, it's the first place they look when a claim comes in. It's kind of a neat segue with our previous topic about surveillance. An insurance company doesn't have to go to the expense of hiring a private investigator to film you when you do them the favor and then post it on social media. And they love to look at particularly vacation photos, not only on your social media post, but maybe your relative's social media post. Maybe your daughter has filmed you in a tug of war down in the Cayman Islands, or you're dancing the hora at a wedding. So social media is the first place that insurance companies look, and I counsel all of my clients, all of them, to stay off of social media. Is an independent medical evaluation really independent? Well, I'll tell you, it's really neither. It's neither independent nor is it medical in most cases. This is because, oh, by the way, if you find yourself going to an IME, you know your claim is in trouble right then and there. It should send up red flags right away, and you should get in touch with an attorney. Because if the insurance company is going to the expense to send you to an IME, you ought to be sure that they want a certain result. So they're not independent. That's because most of these doctors who perform the IMEs are on the tail end of their practices. In fact, a lot of IME physicians, the independent medical evaluation, I like to call them insurance medical evaluations, they make up most of their income. Now, if you have an insurance medical evaluation or an independent medical evaluation, and let's say the doctor frequently finds that you are indeed disabled, well, you can bet your bottom dollar that they're not going to use that doctor much longer. By they, I mean the insurance companies. So insurance medical examiners have a real incentive to downplay your symptoms and find that you are not disabled. In fact, they really do a very poor job of interpreting the medical records. Quite often, they don't even they'll write their initial report and then they send it to another company who then edits the reports to make it more favorable to the insurance company. A good piece of advice is if you're going to an IME, number one, I think you ought to call an attorney at that point. But number two, take someone with you. There's no prohibition to bringing a neutral observer with you to an IME. Now, the insurance companies may give you a tough time. And if they do, try to prevail upon them and convince them to let you take someone with you to the IME. If they won't allow you to take someone with you to the IME, a neutral observer, well, you're still going to go to the IME. It's just, if you don't go to the IME, your claim most likely will be terminated. But these little nuances, that's why you want to speak to an attorney.